Robert Bateman here, and boy have I got a privacy corner for you this week. I'll be looking at a very significant case involving the European Commission, Facebook login and non-material damages. Texas has brought the first action under its Data Privacy and Security Act against an insurance company that allegedly secretly sold the driving behavior of millions of people. And the CJEU says controllers cannot ask you if you're a monsieur or a madame for the purposes of personalizing communications under the legal basis of contract. So before we get started, a big thank you as always to Profado AI, the sponsors of this show. And I just want to mention again their Bridge Summit 2025, which is taking place on the 5th and 6th of February. I'll be involved in two panels, one about ad tech privacy risks and one on the regulatory landscape of the US and the EU. So I hope to see you there. I'll put a registration link in the comments. So first up, this general court case, a very smart piece of litigation by Thomas Bindel, who runs a company specializing in data protection class action cases. It was supported by Spirit Legal, a very talented group of data protection lawyers. And there are three things to remember before we get into this. One, this case is against the European Commission, which is not bound by the GDPR, but Regulation 2018-1725, which regulates data protection among the EU institutions. That said, there are still GDPR implications here. The law is essentially very similar for our purposes. Two, the alleged unlawful transfers here took place after Schrems 2, but before the EU-US DPF was established. So it would be quite a different outcome, I think, if this case had taken place now. And three, this is the general court, not the CJEU proper, so it could be subject to appeal. But despite all that, it's still, as I said, a very significant case. So there are several claims for damages here. We're interested primarily in two. Bindel visited the European Commission's Conference for the Future of Europe website on a few occasions, and he alleged, first of all, that the website's use of a content delivery network, a CDN, AWS CloudFront, resulted in the transfer of his personal data to the US. He also used Facebook login to register for an event on that website, and he said that resulted, again, in the unlawful transfer of his personal data to the US. And there's also some stuff about the Commission's late response to a subject access request, but we're not going to worry about that. So on the AWS issue, there's kind of two sub-allegations here. Firstly, that AWS CloudFront sent Bindel's IP address to an edge server in Newark, New Jersey. Now, the court actually found no evidence of this. They said they couldn't see that the IP address had been transferred to the US. It seems to have only been moved around various servers in Europe. But Bindel also said, even if that was the case, even if it hadn't left Europe, the AWS is still bound by US national security laws and would be obliged to provide his personal data to the authorities on request. And he alleged that this in itself constituted an unlawful transfer of personal data, even if his data never left the EU. Now, the court did not buy into that. They said the mere risk of a transfer does not constitute a transfer. Noib tried something similar in some of the Google Analytics cases a couple of years ago and also did not succeed. But Bindel was successful with his other claim. This is about Facebook login. So he logged into Facebook using his Facebook account on the European Commission's website, and that involved the transfer of his IP address to Meta in the US. And this was deemed to be unlawful by the General Court. They said the Commission had committed a significant breach of a rule of law intended to confer rights on individuals. Now, there were no SCCs in place, and obviously there was no adequacy decision. Even if the Commission had put SCCs in place, I'm not sure it would have solved the problem. This is suggested by all those Google Analytics cases. But nonetheless, Bindel successfully obtained damages in this case. €400, so not a huge amount, but think of the number of people that log into things using Facebook login, and it becomes a very large amount. So the non-material damage occurred because Bindle was put in a position of some uncertainty as regards the processing of his personal data. And this data transfer caused him non-material damage consisting in a loss of control of his data and in being deprived of his rights and freedoms. So we had a similar case in the UK a few years ago, Lloyd and Google, and that claim failed because the UK court said that loss of control of personal data is not non-material damage in itself. You need something like distress caused by that loss of control to make a successful damages claim. But here in the EU, well, there in the EU, I should say, loss of control of personal data is now officially recognised by the General Court at least, and some previous case law at the CJEU as a form of non-material damage. So that really does open the door to some pretty significant class action cases. So watch this space. Second up, Texas, has started enforcing its Data Privacy and Security Act. This is one of the stricter of the comprehensive laws that have come up in the US. I think there's over 20 now. And it's the second one to be enforced after California. So a very interesting case. If it succeeds, then the Attorney General will have stopped some really quite risky and arguably harmful processing. So let's get into it. It's against Allstate, an insurance company, and various subsidiaries trading under Arity. Allstate amassed the world's largest driving behavior database, derived from trillions of miles of consumers' driving behaviour. These are their words, not mine. And the AG alleges that Allstate sold this data to other insurance companies without giving proper notice or obtaining consent under the TDPSA. They also said, along with that comprehensive privacy law, Allstate violated the Texas data broker law and the Texas insurance code. So there are two ways that Allstate got the data that it put into this database. Firstly, they have a software development kit, an SDK, and they paid developers to integrate that SDK into their mobile apps. So it was sitting on millions of people's devices, quietly collecting data from their GPS, accelerometer, gyroscope, and magnetometer. And this revealed information about people's journeys and their driving habits. So the second way they filled this database with driver behavior data was by buying it from car manufacturers. So the case lists Toyota, Lexus, Mazda, Chrysler, and some others. And that supplemented the data they collected from their SDK, could be purchased from the database too. So among Allstate's customers were other insurance companies. And this is quite a big deal because they would use that data allegedly, to justify increasing people's car insurance premiums, denying them coverage, or dropping them from coverage. So the AG says that this was particularly problematic because the SDK could not distinguish whether someone was actually driving a car when they were in a car. It could have been a bus, taxi, a friend's car, so they might have been penalised for other people's bad driving. Now, the allegations under the Texas Data Privacy Security Act are numerous. Firstly, no privacy notice. Secondly, because there was no privacy notice, they didn't have one of these mandatory disclaimers that controllers need to have in Texas. You're supposed to say, notice, we may sell your sensitive personal data in your privacy notice. They also processed sensitive data, that is precise geolocation data, without consent from consumers. That is required under almost all these comprehensive privacy laws, except California, Utah, maybe Tennessee, don't quote me on that. And you need to have consent also. You need to offer people an opt-out for selling personal data and targeted advertising and profiling, which Allstate also allegedly failed to do. Under the Texas data broker law, they allegedly failed to register. And under the insurance code, there were issues with verifying that those car manufacturers had received consent from consumers. So the Texas Attorney General wants the court to impose civil penalties. Those are up to $7,500 per violation under the TDPSA and up to $10,000 per violation under the data broker law and the insurance code. They also want the court to order Allstate to delete this database, all the data they collected unlawfully, and refrain from any future unlawful data collection. So that would mean the end of this database and possibly a pretty massive civil penalty for Allstate. If the court sides with AG, this will be a very big deal. And this is an example of really quite tangible privacy-related harms. And it also shows that Texas is straight off the mark with this law. The minute it came into effect, they started this investigation, brought it to court within a few months. And, it's not an unreasonable interpretation of the law, but it's a very sort of clever use of it to get to some very high stakes data processing. So finally, a CJEU case, a bit simpler than the first one under the General Court. This is about the collection of titles, i.e. gender data. So it involves a data subject named Moose, who is purchasing a rail ticket from an online travel documents retailer, SNCF. And as part of the purchase process, he was required to declare his title, Monsieur or Madame, this, of course, being in France. Moose submitted a complaint about this to the CNIL, the Data Protection Authority in France, arguing that this violated the principle of lawfulness, fairness, transparency, the data minimization principle, and Article 13. So no legal basis, he said, and they couldn't tell him the purposes because the purposes were invalid. Data minimization, it was unnecessary to collect, according to the claimant. Now, surprisingly to me, the CNIL dismissed Moose's complaint and found that this collection of data was necessary. So the retailer wanted it in order to personalize communications. So they would open an email with bonjour, monsieur or madame, instead of simply bonjour. And that was allowed under the legal basis of contract, according to the CNIL. And they also said that, well, if not contract, then they probably have a legitimate interest in it, and people can raise a right to object in that case. So the case went to court, and the CJEU sided with Moose. They disagreed with the CNIL that contract was suitable for this because the data was not indispensable for the performance of the contract. You don't have to personalize communications with the data subject in order to sell them a rail ticket. You can just use a generic opener instead. They also had a look at legitimate interest, and they didn't rule it out, but as usual, the CJEU basically closed it off. So thanks so much for your time and attention. That's all from me this week. Check out Bridge 2025, a technical privacy summit. Hope to see you there, and I'll see you in the next edition of the Privacy Corner.